So welcome, that's partly done. My name is Kevin McKenna, I head the employment team here at Kuits. Welcome, if it's your first HR breakfast, welcome back if you've been before. So housekeeping, we'll try and finish at 10. Toilets, if you need them, back by the lifts. If you hear a fire alarm, it'll be real, get out. The stairs are just beside us here, follow me. I'll be first. And then we can meet the liquor store over the road, and then you insert your own joke there about going to the pub this time in the morning. And then questions, if you keep the questions till the end, just so that we can make sure that we get through all of the content. We've got three great speakers, Mark and Claire from the employment team that many of you will have heard from before, and Kirsty Pinnell, a guest star from the corporate team. We're going to basically talk about the beginning and the end of the employment relationship and some stuff about employee incentivisation in the middle. I think that's probably the intro done. I'll hand over to Claire.
Thank you.
Oh, turn your phones off or down.
So I'm going to start by looking at the start of the employment relationship, which is the critical time to ensure that you're getting the basics right and starting off with those right documents in place to pay dividends later, particularly if you find yourself needing to refer to them to justify some later decisions that you will make. So, recruitment. Employment relationship starts long before the employee walks through your door or logs on remotely if they're a remote worker on day one. And from the moment you come into contact with the prospective employee, they'll have rights, albeit limited ones, for now at least. The first point of contact will typically come at this recruitment stage. Fairly safe to say recruitment could be a whole training session of itself. So I'm just going to touch on AI in recruitment because it's a bit of a hot topic at the moment. Okay. So YouGov poll last year revealed that 77% of working adults in the UK are opposed to AI being used to make hiring decisions. However, it is increasingly being used both by employers but also by prospective employees as well when they're making their applications for employment. And a 2024 survey by the Institute of Student Employers found that 21% of respondents were already using recruitment AI tools, and 45% were reviewing their current methods as a result of the development of generative AI. So AI can be extremely beneficial, particularly if you're carrying out a large-scale recruitment exercise, because used correctly, it has the ability to strip out unnecessary information from applications and to remove candidates from the process who don't have the right skills, perhaps not the right qualifications or experience. It can also reduce the inherent personal bias of recruiters and managers from screening processes, but against that, there's an increasing body of evidence and awareness of the risks of discrimination when using AI for this purpose. And the reason for that is because the AI tools work by predicting outcomes based on the data on which they've been trained, which means there's a risk that it inadvertently perpetuates systemic or historical discrimination in your organisation. That can be the case if the data is inaccurate or you've got poor quality data, and sometimes it can just result in an unexpected or unwarranted outcome for either a particular individual or a group of individuals that share certain characteristics. So put simply, there's a bit of a risk that it reflects the demographics within your existing workforce and prefers those candidates that are the same or similar to the people you already employ. Amazon have had some issues with this recently, and they had to scrap the use of their AI recruitment tool because they discovered that it was inadvertently preferring male candidates for roles in the warehouse. Now clearly that wasn't something that they'd ever asked the AI system to do, but that's what was happening in practice, and of course that then gives rise to potential risk because job applicants can challenge alleged discriminatory decisions under the Equality Act. And if you're facing that type of claim, the machine did it is not really going to be an effective defence, is it? When it's clear that you should have identified a problem with the systems that you are using and taken steps to overcome and eradicate those issues. So other risks around using AI can include processing excessive information about candidates, for example, where your AI tool is taking information that is publicly available, but which wouldn't normally form part of either a CV or an application form, usually something on social media, that type of thing. And so you also need to make sure that you are complying with your data protection obligations when you're processing the data and where you use the AI to make automated decisions, that you fall within the specific legal requirements for doing so. Now, in the next 12 months, new data protection rules will come into force, which may in some circumstances make it easy for employers to process personal data. And if you subscribe to our HRE bulletin, you'll have seen the excellent article from our colleague James on this earlier this week. And obviously, if you don't already subscribe, make sure you get signed up before you leave this morning. So, some top tips if you want to use AI for this purpose. Choose your software carefully. Not all software is the same, and you need to understand how it works and what the risks might be in using it. Data protection impact assessment is going to be your friend in this regard. Should be carrying that out before you sign up to use a particular AI program and roll it out, but you also need to make sure that you keep it up to date and subject to regular review. And linked to that, it's important to make sure that there's some real quality data that's being used, because that's going to help minimise the risks of bias. Okay. You also need to be really clear on how you're using AI and how you're processing the data. Any recruitment policy that you have needs to be up to date, as does your privacy notice, and you need to let the candidates know what to expect. And that includes making your position clear for candidates on how they're going to use AI and if that's acceptable or not. Now, using AI can be a reasonable adjustment for candidates who have disabilities, but encouraging its use can also discriminate against some people with disabilities and may have intergenerational impacts if you find older candidates are less familiar perhaps with its use or less likely to use it, and therefore could find themselves being penalised in comparison to younger candidates. So it's important really to keep it under review and have that human element as part of the process as well. As we always say, compliance is going to be important, so you need to maintain your records, carry out regular audits of your provider, what results it's delivering and the outcomes, and that really is where the human oversight is going to assist in identifying any apparent bias that you may have in your selection process, so that you can start to think about how we overcome that. Okay. So, once your computer said yes, you found your perfect candidate, the next step is making the offer. Now, there's no obligation to make an offer of employment in writing. Those of you who've been here before, it will come as no surprise that we're going to say we'd always advise doing so, because that offer letter is going to be a really critical document in evidencing what terms of offer you've made. So if you are making the offer verbally because you like the buzz that comes from telling somebody they've been successful, and who doesn't, let's face it, follow it up in writing, because that's going to be your evidence of what was said, what was offered. Typically, offers will be conditional, so that means that there's certain things that the employee has either got to do or evidence before the employment contract's entered into. Most likely, as the slide says, are going to be references. Satisfactory references is usually the phrase that's used. Might be around providing evidence of qualifications or licenses, depending on what the role is. Employees may be subject to DBS checks if they're carrying out certain roles. Right to work checks, important as well. And in some cases, medical questionnaires, and sometimes confirmation that there are no post-termination restrictions. Now, the clearer the conditions are, the greater the chance you're going to have of being able to rely on them. But bear in mind that these conditions might not just be your conditions. So where you've got employees who perhaps work closely with your clients and customers, perhaps they're going onto their sites, they may have their own conditions or requirements that need to be complied with as well. And if that is the case, that also needs to be set out in the offer letter. But before you just merrily impose into your offer letter what your customers are telling you, you do need to think about, well, are those conditions actually necessary for the job, and can we justify them? When you're making your offer, you might want to think about putting a time limit on compliance with the offer automatically lapsing after a certain period of time, and that helps to avoid the risk of the offer just remaining out there and open until it's either accepted, rejected or withdrawn. So lots of organisations will have sort of standard conditions, either for specific roles or generally. You do need to make sure that they're tailored to the job role, and also that the person making the offer uses the right template. So I recently advised a client who needed to withdraw an offer because the candidate had failed their own client's background checks. Now, the problem with that was that the person who'd made the offer used the wrong template, and there was no requirement in there that the employee had to pass the check. So it wasn't a condition of the offer. It had never been communicated to the client. So again, really easy to do, isn't it, where you've got lots of people sending out offers and they perhaps don't know what the template they should be using. It's really important to make sure that it's accurate. I'll explain to you in a minute what happened and what that meant in terms of their ability to withdraw it. When you're imposing the conditions, though, you do still need to be alive to the risk of discrimination. So, classic example, if you're asking for proof of right to work in the UK, request that of all candidates, not just those who you think or a recruiting manager may think may be of non-British descent. Medical reports and questionnaires, potentially fraught with risk as well. Obviously, depending on the role, you may genuinely need to know that somebody is physically capable of carrying it out. You might also want to know the extent of any reasonable adjustments that you need to make so that you can make sure you're complying with your obligations as well. Cases, you shouldn't be asking for medical information before the offer's made, and you also still need to ensure that whatever you're asking for is actually relevant to the role and it's not just a bit of a fishing expedition. I'll leave Mark to talk about prospective candidates and whether they're subject to restricted covenants shortly. So, where your offer letter doesn't set out all the terms and conditions that are going to apply to the employee, and they're going to be given a detailed or more detailed written contract later or a Section 1 statement, you should be stating that the offer is subject to contract, because otherwise there's a risk that when you hand over the contract, the employee doesn't like one of the terms, that they're going to then try and argue, well, you're varying what we'd agreed, or you're trying to vary what we'd agreed. So if you make it subject to contract, you're going to avoid that. Of course, if your offer letter sets out all of the terms, so it spans, perhaps to 10 plus pages, that's not going to be an issue because you've got everything in there. And similarly, where you've had perhaps negotiations, discussions about the terms, whether it's been verbally or back and forward over email, again, when you make that formal written offer and any subsequent contract is sent out, you want to be saying in that document is the entire agreement, because again, that helps to avoid a later argument that we agreed something else or something in addition, and it's just that the letter wasn't fully complete. Okay. So, withdrawing the offer. What happens if you've made a mistake? Pre-employment checks come back, they're not the right person, you might lose a major customer, no longer need to expand your workforce. Whatever the reason, you might think, well, this is relatively low risk. Those prospective employees haven't got the service requirement to bring an ordinary unfair dismissal claim, at least for now. Because according to the government roadmap that was published earlier this week, day one unfair dismissal rights will be enforced from 2027. Again, for those of you that subscribe to the bulletin, there'll be a bit more on that coming out later today. So if you don't subscribe, sign up now. However, still a risk of automatically unfair dismissal claims, and more typically, potential for a discrimination claim if you withdraw in an offer. We do see those claims being brought against clients, but the biggest risk is around the claim for breach of contract. So, your starting point, if you're considering withdrawing the offer, is to check, has it been accepted? An offer that's not been accepted can simply be withdrawn. No requirement to give notice. Employment contract is the same as any other contract in that respect. However, to minimise the risk of the disgruntled candidate alleging breach of contract or perhaps discrimination, you need to evidence that you've actually withdrawn the offer before it had been accepted, and where possible, give the reasons for doing so. That's going to help mitigate against those later risks of a claim. And if you are putting forward reasons, you need to be fairly certain that those are valid reasons, that you've got some evidential basis for having. Okay. There is a potential issue where an offer and a withdrawal cross. Using something like DocuSign can help with that because you've got clear evidence of when it was accepted. And the reason there's an issue is that a withdrawal of an offer or revocation is only effective once it reaches the prospective employee, but their acceptance is effective on posting. So if you're using old-fashioned Royal Mail, then you've got potential for a bit of a gap. And, you know, with 3-day deliveries, quite a large gap there. Okay. So that's just something to watch. Not often a big issue, but it can arise. Okay. But if the offer's been accepted, the position is different. If you've had a conditional offer, the candidate can clearly be shown not to have satisfied the conditions, you can withdraw it. No requirement to give notice, conditions haven't been met. That's why it's important to have those clear conditions. But if the conditions have been met, offer's been accepted, the only way to validly terminate the contract is to give notice or a payment in lieu. Failure to do so is going to give rise to a breach of contract for which the employee could bring a claim. And the length of notice that you have to give is going to depend on what the contract says, or the offer letter says where the contract's not been sent out. And that brings us nicely to terms and conditions of employment. Might seem really basic, but you will be surprised by how often we discover when advising clients that either contracts aren't legally compliant, or, probably more frequently, they don't contain the terms or protections that they thought they did. As a team, we spend quite a lot of our time working with our corporate colleagues on transactions. When we're doing that, we are reviewing terms and conditions of employment, contracts, all the policies and procedures, and in pretty much every case we look at, we will find something that is not compliant. And that's in businesses of all sizes. It's not just small employers, it can be multinationals as well. Everyone potentially may get it wrong. Recently I worked with a client on updating some contracts they'd inherited following an acquisition, and within it was a statement that the contract complied with the Employment Protection Consolidation Act 1978. I've been doing this job for over 20 years now, and that was a new one even on me, and I had to look it up, I will confess. If you are interested in it, it was partially repealed in '82. The remaining clauses went in 1996 when the Employment Rights Act came into force. The employee who was subject to that term had started in 2024. They were not a pre-1978 employee. So important to keep it up to date. Section 1 statement of particulars. Called because the rules are set out in Section 1 of the Employment Rights Act. These are the minimum terms that have to be provided in the written statement. Since April 2020, there's an obligation to provide these to workers as well as employees. No minimum service requirement, and most of it must be provided no later than the beginning of employment. If there are any changes, Section 4 requires you to update them at the earliest opportunity, and in any event, no later than a month after the change. So we've got on the slide all of the terms that need to be provided, when, whether it needs to be in a single document or by reference to another that's readily accessible. Most of it is fairly common sense, most of it will be known to you, so I'm not going to go through every line you're glad to hear. But what I will do is just highlight a couple of the things that we often see as either being wrong or missed completely. Hours of work. New requirement in 2020 that you have to state if the hours are variable or the days of work are variable. That's the bit we often find is missing. And if there is any variation, how it's going to be determined. Holidays and holiday pay is another one where we'll often see issues, particularly around the ability to deduct any overpayments for holidays. So if somebody's taken more holiday than they've accrued when they leave, your ability to take that money back when they leave their employment. Probationary periods have to include a statement as to whether a probationary period applies, and if you're using a shorter notice period during probation, that should be set out as well. And once those day one rights come into force, that is going to be increasingly important, because we're expecting that different rules are going to apply to employees who are dismissed during probationary periods to those who are dismissed later on. Place of work is another one. Again, pretty obvious, isn't it? Often there will be a place of work specified, but it lacks the flexibility that you might need, particularly if you've got employees working remotely or hybrid, or you need to relocate and there's no flexibility either. Training is probably the other area where we see gaps, and the requirement to set out the paid leave. Often it's just not updated. So April, new right to paid neonatal care leave came into force. That should be included in the statement. And if you want to know about neonatal care leave, if you look on our YouTube channel, the last HR breakfast we did, Jake spoke about that. That's really good. There will be some changes with the employment bill when that comes into force. It's going to introduce new requirements on changes around sick pay. There's no longer going to be waiting days. Probationary periods, as I've said, and how they're going to interact with the day one rights. New duty to inform an employee of a right to join a trade union, and the introduction of bereavement leave. And if you're going to pay for that, obviously that then needs to come into that paid leave section as well. Penalty for not providing a Section 1 statement or not providing a compliant one is quite low. It's either 2 or 4 weeks' pay with statutory cap applied, but it can only be awarded where an employee brings another successful claim. So given that, you might think, well, quite busy, perhaps worth the risk, or I don't want to use the resources that I've got available to me to make sure that we're compliant. But contracts of employment are really important documents, something that is frequently referred to when an employer is looking to dismiss an employee, because it sets out the rules and obligations. Now, your Section 1 statement is not contract of employment, it's just evidence of the terms. And where you've got a Section 1 statement and a contract, it's the terms of the contract that will take precedence. But most employers don't tend to have two documents. You tend to have a single contract that will include those Section 1 statement minimums. So the sorts of extras that we usually see in a contract that you wouldn't have in that Section 1 statement: duties, gives you something to judge somebody against if you've clearly set it out. Also sets the parameters and scope of the role, so if somebody's straying outside their area of responsibility or authority. For anyone who's in a regulated industry, typically financial services, healthcare, teaching, law, often you want to put your regulatory obligations in there as well. Confidentiality can be really important. Mark's going to talk about that, as well as garden leave, pylons and restrictive covenants. And then the other thing you probably want to think about is intellectual property rights. More important in some roles and industries than others, but a correctly drafted clause can extend the scope of your protection and ownership beyond just what the employee creates in the course of their employment. So, hand you over to Mark. Let's talk about restrictions.
Fun this way. Okay, morning everyone. So I'm going to spend the next 15 minutes telling you why restrictive covenants are worth the paper they're written on. And as a team, we do quite a lot of this work. One of the few employment teams in Manchester that will act in both pursuing litigation and also defending individuals against litigation of this kind. In terms of the touch points for restrictive covenants, commonly you'll find it will relate to lateral hires, as Claire mentioned. So when you recruit somebody, within your checklist, always worth considering whether this individual brings any baggage with them in terms of any restrictions that potentially would impact the business and cost the business. You've also got current staff, Just check that your key staff have covenants which are fit for the purpose. People will progress in an organisation and will obviously get promoted, and their job role may change. So just ensure that the covenants are kept under review and are in keeping with the role and the risk to the business. Obvious point, relevant for key talent leaving the business. So you probably have a look at the contract and just actually see the extent to which they are perhaps locked down, what they can and can't do, or do they pose a risk if they leave and join a competitor or set up in competition. And also it's relevant for business valuation, as Kirsty we'll talk about kind of employee incentivization. In terms of the valuation of a business, that will be dependent on, for example, if you're looking to sell the company, if you've got an exit plan over the next few years, or if you're trying to attract outside investment. Having really robust restrictions can really help preserve the value in your business. As a general rule, courts view post-termination restrictions as void and unenforceable unless the employer is seeking to protect unless the employer can show they're seeking to protect a legitimate business interest. Legitimate business interests will include confidential information, know-how. It will include your workforce. It will include customer connections and also supplier relationships. So anyone within logistics might be a key employee, and you'd want to ensure that they're not going to disrupt the supply chain when if they leave a business. Other interests I've seen in contracts of employment, we've incorporated some relationships around partners of your business, or perhaps even introducers of business. Again, is another proprietary interest that you can safeguard within contracts. Importantly, the restriction must be reasonable. It must go no further than is necessary to protect the legitimate business interest. So if you've got a non-compete that applies worldwide for a significant period of time, and ultimately what you're looking to do is to safeguard confidential information with a shelf life of a limited period, then it's likely to be struck out because it just goes further than is necessary to protect the shelf life of that confidential information. The types of restraints within a contract of employment, you've got your non-compete, which many may have. Non-compete's probably one of the most onerous restrictions you could put in a contract because potentially deprives somebody of earning a living elsewhere, and therefore will attract the greatest scrutiny from a judge in terms of why it's necessary that it's in. Usually it's there because you're trying to safeguard confidential information, or you're trying to police customer connections that may follow a member of the team that leaves. The government, some of you may be aware, and we have talked about it in the HR breakfast seminars before, the government were consulting on the potential, the old government I should say, Conservative government, were looking to potentially remove non-competes in business, or at the very least limit non-competes to a period of 3 months. That was under consultation, I would say, 2-3 years ago, and it's kind of just gone away a bit, so nothing has come in. So as it stands, non-competes are still lawful and obviously subject to principles of reasonableness. Other restraints you might want to cover in your contract: non-solicitation and non-dealing of customers and prospective customers. That will very much depend on whether the member staff has got some interface with your customers, is perhaps quite senior in the business and could potentially take a relationship with them if they were to leave. Also, non-poaching of key staff. And in your contract, you might just want to identify actually who the key staff are. I see so many times in contracts where it just applies to all staff in a business, and that's not narrow enough. So potentially it could apply to people on the shop floor, could apply to cleaners. Where actually I think what you're probably more interested in is perhaps the people that might leave and potentially take relationships with them. They're the key talent that you perhaps want to lock down. So just be careful how you craft your provision. Team moves as well. We have a group of employees that get together, collude, and between them think, well, they'll take away your business. And it might be a common tactic we see is where within that group you'll maybe get the junior employee, or the employee that's got the lightest restrictions will be the one that is pulling everything together evidentially and looking to kind of navigate around the restrictions on behalf of the group. Sally Bird and her team does quite a lot of this work and has had a lot of success over the years, both in pursuing claims for employers and also acting for teams as well, in terms of trying to navigate around contracts and move to competitors. You've also got interference with supply chains, as I mentioned before. Important that you have a provision in that your employee will not disrupt any supply chains when they leave. In terms of the work we do with clients, in terms of the contractual restrictions, a really good idea is to think about actually why you need a non-compete in place, why you need a provision to stop an individual from taking a customer relationship or a prospective customer relationship. The body of evidence can be really helpful in that regard and can actually help form the evidence that you might rely on if you potentially pursue an action in court. So the body of evidence will be, we'll work with clients to set out an explanation as to why a non-compete is required, why a non-compete is required for a certain period, what are the interests you're looking to protect, customer relationships, who are the customers you're looking to lock down. So that can be really powerful evidence to draw upon at court. Duration of restraint very much depends on seniority of the employee and the risk they pose to the business. Again, High Court judges just don't like standard contracts that where everyone is subject to a 6-month non-compete or a 12-month non-compete. You really need to just think about how you carve it to ensure that it's relevant to the applicable rules. Generally, 4 to 6 months is common for a period of restraint. I think any less than maybe 4 months, you potentially might find it difficult getting into court in reasonable time and having enough time for a relevant order to be made. So I think anything over 4 months is recommended. 6 months is possible for senior people. I've seen over the last couple of years High Court judges enforcing a 12-month non-compete against people who work in professional services that perhaps have a really strong relationship with customers. Stockbrokers as well notoriously will be subject to longer periods of restraint. Also, in commercial agreements, so talk about share option agreements, there's perhaps there's more flexibility to impose a longer period of restraint on a senior employee. Also remember any garden leave offset. If you have a provision around garden leave, usually the garden leave would be offset against a period of restraint. If you don't do that and a non-compete for 6 months plus a 3-month garden leave period, that's a total of about 9 months. You're restricting somebody, that's unlikely to be enforceable in most cases. As well as express duties, you've got implied duties in a contract of employment. All employees are subject to an implied duty of fidelity, which essentially is things like not misusing confidential information, not diverting business opportunities. It's important to note implied terms do not extend after the termination of employment, so they're just during the currency of employment. Fiduciary duties as well will apply to senior employees and directors in businesses. The penalties are a lot harsher for breach of fiduciary duties. It could cover an example where a director may set up a secret business during the course of their employment and potentially look to operate that business and gain that competitive advantage when they leave. Apart from restrictions, other means of protecting the business. As Claire mentioned, having really tight confidentiality clauses, having quite prescriptive clauses that actually define what you mean by confidential information, giving clear examples. Consider longer notice periods. So if you've got key employees that are on 1 month, that perhaps you might want to look at extending that to 3 months or even 6 months in some cases. Garden leave is a great weapon in your armoury to keep an employee at arm's length during their notice period and keep them away from customer connections. Controlling access to systems. So I know some employers will look at layering access to databases. Not everyone will perhaps hold the keys to all the data and all the confidential information within the business. I've also mentioned repayment of training clauses. This is something that I came across a few years ago, acting for a well-known Thai restaurant chain that was recruiting Thai chefs, bringing them over to the UK, training them up, investing probably £5,000 to £10,000 per head every year, and competitor down the road would be poaching them. I know. So one thing we consider was perhaps a non-compete just wouldn't be appropriate. It just wouldn't work here. But what we could do is, bear in mind, there's a lot of investment. We put a repayment of training clause into the contract, and it acted as a sufficient deterrent because gradually those numbers declined, and they were able to kind of lock people down for longer. It'll work the same way as a bonus. If you pay bonuses, then you might want to make that subject to future commitment to the business. And if they leave in a certain period, then they potentially would lose the bonus. Really good practical way of just deterring people from leaving your business. Employee surveillance. Some of our clients will use software that will detect any suspicious behaviour and can be a really useful tool that employers call on as well. Obviously, make sure you're compliant with data protection laws and any GDPR policy you may have. Also, if you're incentivizing the employee with shares, which Kirsty will talk about shortly, then there may be a separate commercial agreement. So there may be restrictions in another agreement that, again, gives you that opportunity to perhaps lock the employee in for a lot longer. Right, so you're faced with a key employee that's leaving. What should you do? First of all, check the resignation letter. That tends to be an opportunity to see if the employee is looking to perhaps to leave. Normally, if an employee raises a grievance or a complaint at that stage, and that's the first time they've done it, that might give you an inclination that perhaps something is not right here, and they are potentially looking to jump ship. We see a lot of employees that will throw in arguments that they've been constructively dismissed. So you have fundamentally breached their contract. And the legal effect of that would be that it would discharge any ongoing post-termination obligations in a contract of employment, apart from confidentiality. So that's something to be just aware of in terms of resignation letters. Exit interviews are always a good tool as well to use, just to kind of understand the reason why an employee is leaving, what they intend to do. If you're in the position where you are suspicious of what an employee's intentions are, then great chance to interrogate them before they leave. So what are they going to do? Are they doing it? Who are they going to do it with? And that might just open up potentially the opportunity then to carry out a sweep of any company property they have. So computer, mobile phone, these things tend to show up any digital footprint of any unlawful activity. Employees tend to plan for their exit as well, so they tend to, if they're looking to take anything with them, confidential information or customer connections, you may see the build up to the resignation letter where they've downloaded information, they've sent emails to their personal email address. So all that is potentially suspicious activity that you should be live to. At that stage, you might want to consider the benefit of garden leave. Again, putting them on garden leave, keeping them at arm's length from the business. I've had an employer in the past that has done it in alternative months. So a senior person was subject to 6 months notice period. Put them on garden leave the first month, brought them back the second month, and so on, just to kind of play with the employee's mind a bit. Again, just ensure you get collection of property. Just be mindful not to breach the employment contract. So if you put somebody on garden leave for, say, 3 months, and they're contractually entitled to some company property, perhaps a mobile phone for personal use, then just be mindful that you can't necessarily take that off them. Or if you do take it off them, make sure they have a replacement device. Really good idea is getting a handover note from an employee as well, just to get a list of any customers that they've perhaps had ownership over, any live matters. Where possible, ensure introductions are made to other team members of any key client relationships. Document everything you do, because all this could be evidence in potentially going to court. I know if everyone's in the practice of perhaps reminding employees of any post-termination obligations when they hand a resignation in or when they leave. Again, that good practice, just to kind of focus their mind on the restrictions. You may also want to consider writing to a new employer to make them aware of the restrictions, which again can be helpful to ensure that the restrictions are policed. At the very least, send a marker that you're potentially going to watch activity and you're not going to hesitate to sit back and watch them exploit their contractual provisions. Importantly, keep a watch on things as well. Okay, employees that are looking to kind of navigate the restrictions always slip up somewhere, where it be errant emails, or I've had some employers in the past have actually paid for employees to be followed. I wouldn't recommend that, but again, just be mindful. I think the computer and mobile phone suite is again a great tool that you can use effectively. Finally, in terms of legal action, commonly, if there's sufficient time left on the period of restraint, you might consider an injunction. You do need to move quickly with that, so it's not something you can sit on for a few weeks. I think Pete's here from our litigation team. I think Pete maybe would agree with me that in most cases you would go on notice with these things. You would you'd send a pre-action letter to your opponent, setting out the precise breaches and invite them to respond, whether they accept it or not. Ultimately, you may end up before a judge and you're requesting an order that the status quo of the contract is preserved. Okay, so that might be the non-compete. That might be saying to somebody, you can't work for a competitor for 6 months, or you can't deal with these customers for the relevant time as well. Injunctions involve a lot of work normally in a short period of time, which is why going back to that point about having your body of evidence, having your cultured restrictions, having all that evidence ready is crucial in these types of cases. They're also very expensive, particularly if you're on the receiving end of an injunction. And I think in most cases where you're pursuing, seeking an injunction against an individual, you may find that the individual will just fold because they haven't got the deep enough pockets to fight this. So again, it can be useful. We've had a lot of success in the team over the last few years in terms of securing injunctions, some great results for clients. As part of that, you can also claim damages for any loss of profits arising from any breach of contract, and you can recover your costs as well in terms of pursuing that action. Okay. In terms of one thing to take away today, if you are looking at key talent, look at the contracts. Just make sure that they're fit for the purpose, they're relevant to that individual, and they adequately protect the business, because ultimately it will be the valuation of the business that will suffer. Okay. So I'm going to pass you over to our guest speaker, Kirsty Pennell.
Thanks, Mark. So, hi, I'm Kirsty. I head up the corporate team here at Kuits. So, mainly deal with M&A, buying and selling businesses to companies, and employees are usually key for that. And I will reiterate, employment contracts are very important, and buyers are concerned to make sure that we protect, or that the target company is protecting its confidential information through their employment contracts with super restrictive covenants, and they are fit for purpose. So, yeah, please make sure those are lined up. Otherwise, how can we incentivise employees in the corporate team? We do end up dealing mainly with equity incentives, so cash can be king, but we usually look at, can employees have shares or options, the right to buy shares? So in terms of that, key points to consider right at the very beginning, it's sort of, there's the legal, obviously I'm a lawyer, so looking at the legals, how to implement what we're implementing, but there's commercial drivers behind it that are important, and don't ever forget about the tax. The commercial rationale, why would you want an employee to have shares or potentially have shares? What are you trying to bind them into? You want them to really feel invested in the company, that in the business itself, that they care about it, they want it to grow in value, because then they will end up with more money in their pockets at the end of the day. So it can be used to attract, keep talent, and also to retain employees, and to make sure that the interests are aligned throughout. Ownership, so some of our business owners who want to tie employees in, keep their interests aligned with the business, don't really want the employees to interfere too much with the business. So usually we're talking